Hello everyone and welcome to the Activist Lawyer podcast. My name is Sarah Henry and I'm your host to this podcast, which offers a platform for lawyers to share their story and their journey into law and activism. Our guests will discuss the challenges and highlights of their work, as well as important cases, opinions on legal and political matters, and will offer up advice and tips for anyone interested in pursuing a career in human rights law, public interest law, or criminal justice. The Activist Lawyer podcast is brought to you by the Granite Podcast Studio. Thank you so much for listening. Today I am joined by Kier Monteith KC from Garden Court Chambers, who will be sharing insights into the important work that he's been involved in. So in this episode we focus on a particular case, but it's part of a broader discussion that highlights serious racial injustice within the criminal justice system and the dangers of relying on flawed evidence, but also harmful stereotypes in legal proceedings. So we're looking at the issue primarily of rap lyrics and so-called gang evidence, and how these factors can seriously undermine justice and indeed destroy lives, as you will hear. Kier is also involved in the Art Not Evidence campaign, which is a powerful initiative aimed at raising awareness of these issues. So I'd highly recommend checking out the website Art Not Evidence for more context on today's discussion. It's really eye-opening and something I plan to follow closely with the Activist Lawyer podcast, having spoken to Kier about this issue. Kier is such a passionate and compassionate and incredibly dedicated lawyer, and it was a true pleasure having him on the show. So I hope you enjoy this conversation as much as I did recording it. We do talk about the merch for Art Not Evidence, and if you did enjoy today's conversation, please like, share and review where you can. I am delighted to be joined in the studio from Sussex, I believe, by Kier Monteith KC. Thank you so much for joining me.
No, and lovely to be invited on. I'm really looking forward to our chat this morning. Thanks very much.
Delighted to have another member of Garden Court Chambers on the podcast. We've had quite a few and it's always been an interesting conversation. So delighted to share your work today, which is quite specific, and we'll get into the content in a little bit. But I'm wondering, can you take our listeners back to where it all started for you in terms of your legal journey, and who or what inspired you to become a barrister and to work in this area of law?
Well, it's a long time ago for me. I mean, it's literally, hate to say this, but last century. Yeah. I know it's wearing, isn't it? When I started out, and going back to my, late teens, I suppose, all I knew at that particular point in time was that I was, I don't know if I was particularly good at arguing. I just argued. And looking ahead in terms of what I could do in my life, I thought, well, that's what lawyers do. So that's what my choice was: do law, argue with people and see what happens. And here we are.
Here we are, still arguing. Doing great work. And of course, Garden Court Chambers is known for its progressive approach to criminal justice, I think in particular. But you do other work there as well, human rights and public law. How is your experience, I suppose, with this particular chambers, and how does that maybe shape your work? Is there a camaraderie there? Is there support between colleagues to kind of push your work on and gain momentum with the areas that you're fighting for and arguing?
It's a very inclusive and progressive chambers with a lot of role models across the spectrum of law. So you look up, you see fellow colleagues fighting the fight, pushing the boundaries in relation to many areas of law, and it's inspiring. It's inspiring. And there's a great history of that. And there's an awful lot of support, because we often go out on a limb in relation to some of our submissions or what we say. And we have a motto at Garden Court: do right, fear no one. And that's exactly what has to happen, particularly in this day and age. But I've got to say this as well. It's not just Garden Court. There's loads of other chambers doing phenomenal work up and down the country. There's another chambers that also uses the name Garden Court North. Incredible stuff up there.
That's right.
At the moment, working on Hillsborough law, for example, and turned around this government yet again when they were trying to wreck the Hillsborough law going through the Houses of Parliament. So can I just also include solicitors, because it's not just chambers and barristers, solicitors, again, up and down the country, doing incredible work, and long may it continue.
Brilliant, brilliant. Well, look, your work, as you said, you've got a quite expansive career in law and in criminal justice, but we're going to focus on something quite specific today, and it also involves some campaign work that you've been involved in. So Art Not Evidence and the use of rap lyrics in court is something that we might dive into for the next few
Yeah,
moments. And
absolutely.
well, your involvement with Art Not Evidence, and we will share links to this in our show notes, is, I mean, a perfect example of using law as a tool for justice and for cultural justice. Can you maybe explain a little bit about your involvement in the campaign and what the aims are for the campaign and how important it is for the criminal justice system?
Yeah, it's incredibly important. I've just got to maybe correct what you said at the beginning in terms of using the law, because at the moment, generally speaking, the law is used against people who have created a rap or a drill video. And that's why we have the campaign Art Not Evidence. Because unfortunately, the justice system just isn't equipped to change itself and provide a level playing field for those that create that type of art. And if you go to our website, I hope your listeners will do, you'll see there some draft legislation, the Creative Expression Bill. And when I talk about this, actually, honestly, when you come down to it, it's just like a polite request. It's not radical. It's just, please don't use rap lyrics, drill lyrics, creative expression in these serious cases as evidence of gang membership or bad character or intention to do violence. Just please don't do it. And in a sentence, the draft legislation states that that type of evidence, starting point, should be that it's inadmissible unless a series of conditions are met.
Yeah, gosh. And Tyrone Houghton, I know you've been working with, there was a film release, is it 16s to Life, which explores this kind of intersection of rap and the law, really emphasising how lyrics can be misinterpreted as literal truth. From a legal perspective, how should courts be handling this and how common is this? I mean, I know it's something that you've been working on very closely, but a lot of, what's said in this artistic expression is hyperbole, metaphor, and I mean, how does this present in court as problematic?
So the major problem is that the courts, and it includes the Court of Appeal on a regular basis, take what's in a song, in some lyrics, in a video as being the literal truth. That they don't step back and appreciate that it is art and it's literally there for entertainment on 99.9% of the occasions. So you've got a raft of decisions allowing in videos as evidence, as I said before, of gang membership, of an intent to do serious harm or just bad character. And it's an absolute and utter nonsense. And it happens on a regular basis, unfortunately, up and down the country. On a number of occasions, it's not properly opposed by the defence. The courts are not educated on what's going on by appropriate expert witnesses. Very often, the prosecution calls police officers who may have been on one or two courses to learn about rap.
Right.
Right. But they come into court and profess to be able to tell the judge and ultimately a jury what is being sung about, what is being rapped about, apparently is true on a number of occasions. And that these individuals, after maybe, on the Crown's case, committing a very serious act, disguising themselves, making sure they're wearing gloves and other items to ensure there's no forensic footprint, a few days later then make a public confession to music. And that is then presented to the jury as convincing evidence. And unfortunately, because as a result of stereotypes and the institutional racism that exists in our society, the juries are on occasion persuaded that that's correct. And we have horrendous miscarriages of justice.
That's incredible. And I know you worked on the Manchester 10 case, which is also an example of how gang evidence is relied upon as solid proof. And can you maybe share your involvement with that case and the outcome and how it impacted your clients?
Well, again, got to be really careful about the words that we use. So, the prosecution said there was a gang in that particular case. And I would want to just concentrate on 4 or 5 of those defendants. I could deal with a whole lot, but let's just deal with 4 or 5 of those defendants the prosecution said was a gang. And it included my client, Ademola Adedeji. So let's just deal with him first. At the time, Ademola Adedeji had a unconditional offer to study law at university. He'd been head boy at his college, he'd been captain of his rugby team, and he'd addressed the Houses of Parliament at age, I think, 15. And they were saying he was a gang member. He had no previous convictions. He had no cautions. 4 others, similar situation in terms of no previous and no connection with gangs. And in that case, and it was run by the police, an eminent King's Counsel and junior who were prosecuting. At the end of that case, and something matters up to the jury, and I'm paraphrasing this, the prosecution KC said some of the explanations as to why those 4 or 5 individuals became involved in gang culture was where they lived, the people they associated with, and an interest in drill music, and then went on to say the themes of violence and drugs that they had heard about. And the jury had heard about it because the prosecution had unrelentingly played drill tracks in that trial. So we haven't probably got time to pause in this podcast, but I'd ask your listeners just to reflect that in that case where they said there was a gang, they were focusing in on a person who had an unconditional offer to study law at university. In relation to those 4 or 5 who had no previous convictions, they talked about where they lived, who they associated with, and an interest in drill music. All of those defendants were black. I would suggest that would never be said about white defendants. So first and foremost, we've got to analyse whether there was a gang at all, if that's the type of evidence the prosecution are relying on. In addition to that, and unfortunately this could take up the whole podcast, let's also just deal with what happened in relation to my client, Ade. I didn't deal with him in the Crown Court trial. I only dealt with him at appeal. Mm-hmm. And I just want to just name check 2 people before we go any further, because it's not just me. The solicitor involved, Zachary White, phenomenal lawyer in that particular case. And I've said it before and I'll say it again, he saved Ade's life, right, in terms of legal submissions. And then junior counsel, and she's not junior, she's very experienced, but that's how we refer to them at the moment, Audrey Mogan, who was a great part of the appeal and the submissions and what happened at the Court of Appeal. So in the trial, and please stop me if I'm going on too much. In the trial, the prosecution had the office in the case go through a whole load of telephones that had been seized off defendants. And in one of them, and it was a few months before the actual trial date, he looked at a video. It was about 9 seconds long. And there's a black guy there. He had a blue bandana on his head. And the officer came to the conclusion he was rapping and saying something. And then he went, "That's Ade," i.e. he identified my client. When that evidence was eventually put before the defence, Ade said, "That's not me, it's a guy called Tyrone. You got it wrong." But rather than accepting what Ade said, they persisted, the prosecution, in suggesting it was him because this officer had, quote, recognised him. And they said, this is evidence that Ade is a gang member. And I'm saying this in all seriousness. It's because he has a blue bandana on his head. They're saying it because he's rapping something, and it's something about gangs, they said. And as it happened, there's some music in the background. I'll leave it to your younger listeners as to whether that's drill music or something else. And what's important about this is that they also had Ade's phone, and they searched through that phone and they couldn't find a picture of Ade wearing blue. Now, if you're in this gang, apparently that's the colour that you wear. And rather than just thinking to themselves, well, maybe that means he's not a gang member, they ignored that deficit in their case and concentrated on this contested identification and suggested, there we are. He's wearing blue in there and rapping or saying something about gangs. Very sadly, Ade was convicted, quite possibly on the back of that type of horrendous evidence, despite the fact that he had this offer to go to university to study law. The judge, experienced High Court judge, sent Ade to jail for 8 years. And that's despite the fact that the prosecution agreed at sentence that he had not taken part in any violence whatsoever and had incredible references off the scale in terms of all of his good works. 8 years. And he, at that point, had been remanded in custody and he was taken away. Despite the fact that he had talked about someone else being on that video, despite the fact that there were a number of problems legally with how the judge had directed the jury, his legal team never, ever appealed his conviction. And to be frank, if we hadn't come along, he'd still be in jail now.
Wow.
And that's something to reflect upon.
Gosh.
But we did. And as I said before, Zach White, the solicitor, saved Ade's life because he tracked down Tyrone. He found Tyrone. And a statement was drafted and it detailed the fact that it was him in the video.
Tyrone, yeah.
Yeah, it was him. There was a bit of messing around. There was people who were freestyling. He wasn't rapping. What was said had nothing to do with gangs. And he confirmed he was of good character and he had nothing to do with gangs. He hadn't really wanted to be videoed. That's the type of guy he was. And he'd put the blue bandana on his head to try and just disguise himself. So we served that statement, I think, about 6 months before the Court of Appeal full hearing, and suggested that this completely undermined the prosecution case. And of course, check it out. Check out what's being said here. And if there's evidence to rebut what's being said, serve it. They served nothing. But unforgivably, at the Court of Appeal hearing, rather than doing, I would say, the decent thing, which is conceding that that was Tyrone and the conviction was unsafe, in the Court of Appeal, Court 4, prosecution KC stood up and accused Tyrone of coming to the Court of Appeal to perjure himself. Unbelievable.
My goodness.
Because everybody in that court could see Tyrone and they could see the video. And they could see that Tyrone was the person in the video. And, of course, why on earth would he come to the Court of Appeal to perjure himself? No reason was ever suggested. And that's the extent that the prosecution would go at one of the top courts in our country to, quite frankly, try and keep Ade locked up. Now, fortunately, the Court of Appeal judges who were sitting in exactly the same room and who could see Tyrone and could see the video came to the conclusion, as per everybody else, that it was Tyrone in the video, and therefore the conviction was unsafe. But I reiterate, if Zachary White, the solicitor, hadn't found Tyrone, and if Tyrone hadn't come to court, Ade would be in jail as we speak now. And I just want to end with this postscript just on that particular point and the issue of gangs and stereotype and how far the prosecution can go. When Ade came out of prison, over 1,000 days he'd spent there, he didn't bear a grudge against the prosecution or the police or the judge. Incredible. Yeah. He just wanted them to learn. I'm more angry than he is about what has gone on in relation to his life. He should have finished his law degree by now. And I tell you what, it's worth having him, if you can, on this program. Yeah. He's 10 times better than me. But in this year, I've been with him on a number of platforms. We spoke together at the Stephen Lawrence Day in April of last year. We spoke with students at Manchester University, educating them about what's been going on in their own city. And he's addressed students with Baroness Chakrabarti at Middle Temple. And all of that's incredible. But one of the most significant things is the Justice Conference that was held last year in London. It was opened by the Shadow Attorney General. It was closed by the Attorney General. It involved 3, if not 4, Supreme Court judges addressing all of the lawyers and judges who were in the audience. And in the middle of all of that was Ademola Adedeji on a platform in the middle of all of those great and good from the legal community. And that's the person, a few months ago, in fact, the prosecution said was a gang member because he had a blue bandana on his head and was rapping something. And that's the thing. That's the thing in Ade's approach that these people need to learn about. And so far, unfortunately, they haven't. Right. That's how serious it is. And he's such a great example, I think, to all of us. And I hope a new generation of lawyers that are coming through, because the ones at the moment aren't doing sufficient. I remind you, his lawyers did not appeal his conviction.
Astounding. It really is. Well, I'm just in shock by the detail that you've gone into there. And I mean, this is current. This is as we speak. This is going on.
This is this is what we're talking about now.
And
not going back to the bad old days of the 70s.
No.
This is now.
So the facts of that case and the evidence upon which the trial was based is harrowing and very, very unsettling. But really it just is another example of the continuous kind of systemic racism within both the legal profession, I have to say, but also the system itself. I'm just wondering, I mean, you've mentioned there with Ade, who obviously is an extremely brave person, and thank you for sharing the detail. I hope our listeners will follow up on this. I certainly will. But where are we now in terms of maybe the campaign element? How do we keep this on the table? Because you've mentioned that sadly people have not listened. Is there litigation ongoing in other cases, or how can the campaign evolve to make sure that this is something? I know you've been involved in referrals to the Criminal Cases Review Commission on this very point, but what's currently happening to make sure that this matter is live and dealt with?
So I suppose in relation to listeners wanting to do something, and you'll refer to this maybe at the end, is to join up with the campaign group Art Not Evidence. Yeah. That's definitely something you can do. There's a letter on our website, and you can sign that. It's very easy and straightforward, to the Justice Secretary, expressing concern in relation to the use of rap and drill in criminal trials. And you can lobby also your MP to support the draft legislation, which is on our website. Brilliant. And I tell you what, while you're lobbying your MP about that, can you lobby them about David Lammy? Because this proposal, which never featured in any manifesto from the Labour Party, and I've got to say, never featured in anything that David Lammy previously said. In fact, it was the opposite. He was a great proponent and campaigner for juries because, in his view, I think a few weeks ago, maybe months ago, it's only recently changed, juries were able to provide justice when they're given the correct evidence, as opposed to a judge who's taken from a very small part of society. So when you're lobbying your MP about Art Not Evidence and its campaign, add a paragraph in relation to juries and how important it is that we keep juries rather than replacing them with judges. And I appreciate this as a podcast, but you told me I had to appear on a Zoom link. So I am, but I've taken this opportunity to hold a T-shirt, which is also available.
Rap is art, not evidence. Yep.
There we go. And then on the front, a nice little logo.
Very nice.
So they're available from our Insta shop, and hoodie, which all good lawyers should wear. And I'll put it on.
You're going to be quite warm.
I know where it came off again.
That looks great.
Well, I don't know if it does, actually.
Yeah.
This can replace gowns. Maybe we should have a campaign for that. There we are.
Art Not Evidence hoodie. Loving it. Yeah. Very, very stylish. So where can we buy those?
Look like a trainer. Yeah. So yes, Insta Shop, search it out. Again, I can sort of pass on the links and stuff, so you can add it to the. But seriously, if these one are bought, it just helps our income. Yeah, so that's important because volunteers are doing the campaigning, and we need to update things. We need publicity and stuff like that. And two, if you do know people that have a bit of celebrity about them, fantastic to get a photo of them in a hoodie, in a T-shirt, post it, and spread the message that way. Because Art Not Evidence, as much as it is about law reform, it's also about creativity. It's just phenomenal. You can do with art, with music, with lyrics, with the spoken word. And that's educational. It's entertaining. It's what life should be about. It's not about just limiting stuff. It's about expressing yourself. And that's what us humans should be doing much more of.
It is what we should be doing. And you're a prime example of that. And one of the questions we ask our guests is about that relationship between activism and the law as a tool for social change. And really, you're kind of living that with your colleagues as well in terms of this campaign operating on one end, but also using your skills, your knowledge and your strategies in terms of your legal training to advance this issue and other social justice issues. How important is the relationship between the two?
For me, anyhow, I don't think I could be the lawyer that I've become without involving it's politics, if we're frank about it, within the submissions that I make, because that's what will bring about real change within the law. And if you just keep your head down and read the authorities from the Court of Appeal, particularly on this topic, you won't get anywhere. Hence the campaign to reform the law, because if you look at the Court of Appeal authorities on rap, all of them support the inclusion of that type of evidence, bar one, which is a case that's oddly quite hard to find, called a Limmy in 2014. I don't know why it is so hard to find, but I'm underlining it in this podcast. It is actually of some help. But if all you've done is look at those authorities with your head down, a lot of the time you might not oppose applications by the prosecution. You might not instruct an expert to explain what that rap track or drill track was about. You might not, if your client, let's say, like Ade says, it's not me, it's someone else, go off and try and find them. But if you've got a wider experience and an interest in what lies behind the music, behind the lyrics, about society, resistance of communities, and have a passion in relation to those matters, irrespective of what those authorities say, you will make every effort to try and persuade, in the first place, the prosecution not to even rely on the evidence. And if they do, then you instruct your experts, you construct submissions, and you can use law elsewhere. A case of Skinner in the US, very powerful on this particular topic. Use that and bypass what the Court of Appeal, I think, in an old-fashioned approach to this type of evidence have adopted. And before you know it, you will be persuading judges and prosecutors that they shouldn't be relying on that type of evidence. And just go back to the witnesses, go back to forensics, go back to the CCTV, go back to analysis of cell site. And that's the evidence that should be being put before juries, not music, not lyrics, not spoken word.
Exactly. Well, we've spoken about how listeners can follow the campaign and, of course, can contribute and become involved and support it. But finally, what advice would you have for anybody listening who might want to follow in your footsteps and work, whether as barrister or solicitor that you mentioned to you, in this type of law?
Yeah, well, don't follow in all of my footsteps, some of which we can't talk about. It's a secret. I think a decent amount of it is look to what's happening outside of the law. Would be my advice. And so certainly if you are about to consider what you're doing at college, and if you've done college, what you might do at uni, potentially don't do a law degree. Do something else that you've got a real passion for. It may be politics, it may be geography, it may be archaeology. I don't know. Go off and do that and travel and see the world, speak to people. If you still want to do law after that, it's, I suppose I've been out of the system, but I understand it's a 1-year conversion course. And then with all of that armory, with all of that knowledge, with all of that interest and passion, become a lawyer. And when you embark upon cases, and it's not just restricted to crime, it's, of course you've got to apply the law. But if it's unfair, if it's unjust, there is an argument knocking around, irrespective of the black letter law, as to why X, Y, and Z shouldn't happen, whatever area or jurisdiction you're working in. And you could come back, if you wished, to that Garland Court motto, do right, fear no one, right? Because if you're doing right and you're facing difficult authorities or the establishment, don't fear them, just do right and garner support from chambers like ours up and down the country, solicitor firms up and down the country and elsewhere in other jurisdictions. And you'll make a difference. You will make a difference.
Brilliant. Brilliant. Well, Kier Monteith KC, thank you so much for joining me today. I'm delighted to have had the opportunity to discuss this really important work, and we shall support it where we can here on the Activist Lawyer podcast. Encourage our listeners to do so as well. It's really interesting, but also very, very important. Thank you for your time today.
Absolute pleasure. I will send you a t-shirt in the post if you give me your details.
I will, of course. Yes. Thank you.
All right. Thanks a lot. Bye-bye.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.